and welcome to Stretch Break with Lauri. Today we're going to be talking about pension withdrawal liability, which is a phrase many of you have probably heard but may not fully understand. So I want to walk through what it is, why it exists, what triggers it, and an exemption that might apply to your company. So pension withdrawal liability only applies to defined benefit plans, commonly referred to as pension plans. And those are plans in which an employer or group of employers have made a promise to provide a specifically defined amount of money to retired employees upon retirement each month until they pass away. Because the plans are structured so that the benefit is defined rather than the contribution, they can become underfunded even if every single employer makes every single payment on time and in full. And some of the reasons they can become underfunded is, one, they are reliant on market performance. So if we have a year like 2008 where the stock market takes a huge tumble in 1 year, a pension plan can become underfunded overnight. Another reason that plans could become underfunded, even if everyone is contributing correctly and on time, is man hours could go down very drastically as a result of a recession, for example. Because the funding levels of these plans are based on actuarial projections that assume a certain rate of investment return and a certain number of man hours worked in order to fund all the benefits that have been promised. So, what is withdrawal liability? Well, it's a creature of federal law that was created by Congress in 1980. It's not a matter of contract. It applies to all multi-employer pension plans. Multi-employer pension plans. And essentially what the law says is that if an employer who is contributing to a multi-employer pension plan ceases contributing to the pension fund, and the pension fund is underfunded, that employer can be assessed a payment that reflects its proportional share of the vested benefits that are due to the employees. And the reasons this law were put into place were twofold. They were designed to protect employers and employees, if you can actually believe that. The part of the law designed to protect employers was that so all the remaining employers who did not cease making contributions would not be left covering the unfunded share of the liability of the employer that ceased making contributions. So in other words, they wouldn't have to pick up the tab for the employer who withdrew. And of course, the motive of protecting employees should be more obvious, which is that the idea is to make sure that employees get all of the pension benefits that they were promised. Now, what are some triggers that can actually cause an employer to incur withdrawal liability? Well, the biggest one would be going non-union. So, in other words, ceasing your obligation to contribute to a pension plan via a collective bargaining agreement and simply continuing to do work that's covered by the collective bargaining agreement but in a non-union setting. That would trigger withdrawal liability. And then otherwise ceasing the obligation to contribute. So negotiating that obligation out of your collective bargaining agreement, which would probably never happen, or if you just stop making the contributions. Those events would trigger withdrawal liability. Now, there is an exception that applies to the construction industry that could apply to some employers who are watching this video. Not all of you, but some of you. It's called the construction industry exemption. And the reason there was an exemption made for the construction industry is that probably there were very good lobbyists who convinced Congress that the construction business is very project specific, it's very episodic, and so there will be times when an employer will be making contributions, a project will wrap up, and they'll cease having an obligation to contribute to the pension fund. And they didn't want to be assessed withdrawal liability every time a project wrapped up. So the good news is that if you fall under the construction industry exemption, if you just simply retire and close your doors and stop performing any covered work in the geographic area where you were performing work before, you will not be assessed withdrawal liability as long as you don't begin performing that work again in the same geographic area within 5 years after you closed down your business or otherwise stopped contributing to the pension fund. But the construction industry exemption only applies to job site construction. It does not apply to service work, and it does not apply to in-shop fabrication. So the rule is that substantially all of an employer's work has to be job site construction work in order for that exemption to apply. And the case law that's interpreted that requirement has said that around 85% of your work has to be job site specific in order for you to qualify for that exemption. So that's something you should examine very carefully if you have a fabricating division or a service division or both. This is a very complicated area that I just glossed over. If you have more questions about it, I'd recommend that you listen to the podcasts and the webinars that we've recorded on this topic, which are available on our website or wherever you get podcasts. I'd also recommend that if you are contemplating ceasing your obligation to make contributions to any pension fund, that you consult with qualified legal counsel before doing so. And if you would like more information or some referrals, please leave a comment in the comments section below this video, and someone from our staff can give you more information and point you to a qualified individual. Thank you very much for joining us today.